In September 2016, an unnamed Austrian teenager made headlines around the world when she took her parents to court for refusing to remove pictures of her which they had posted to their Facebook page. According to the 18-year-old, her parents posted upwards of 500 pictures of her over the years, including shots from her infancy and childhood. She claimed that her parents had no respect for boundaries or privacy throughout her childhood, and had posted pictures of her sitting on the toilet, in her underwear, and in other such situations for all of their 700 friends to see. Although she said she had repeatedly asked her parents to take the pictures down for years, they refused to take her request seriously, and so she decided to take legal action the minute she turned 18. As for the parents, they maintain that the photos are their property and that they are free to post them anywhere they please. Although the case is ongoing, the girl's attorney has said that he believes she stands a fair chance of winning. The law is murky in Austria, but it is not so in many other European countries. In France, the country with the strictest controls, one could face a fine of close to $50,000 for posting pics of anyone without their permission, and this includes parents posting photos of their children. A Facebook-related case of a different sort made headlines back in 2010, when Arkansas mother Denise New was taken to court by her 16-year-old son for tampering with his Facebook account. Specifically, he claimed that his mother logged into his account without permission to post slanderous remarks about his personal life, then changed his password so that he couldn't undo the damage. The trouble began when Lane New, who had lived with his grandmother for the previous 6 years, called the police on his mother when she became violent with him after he refused to return a house key. That evening, Denise logged into her son's Facebook account, posing as him and posting the message, "Check this out. I went to mom's house, deliberately started a fight, and called the police on her. She almost went to jail. How cool is that?" In court, jurors heard a voicemail from Denise to Lane, stating that the fight hadn't been her fault because he bruises easily, and announcing her intention to change his Facebook password and continue posting as Lane. In one message, she says, "Have fun with all your little friends responding to what I posted on your wall." Lane won the case, and Denise New was sentenced to 30 days in jail and a year's probation for harassment. In 2008, an unnamed father in the Quebec province of Canada resorted to grounding his 12-year-old daughter after she repeatedly broke his rules about using the family computer. He said that the girl had figured out how to bypass his security measures and log on to websites that she was forbidden to visit, and had posted pictures of herself that were inappropriate for a girl her age. In response, he grounded her, meaning that she could not go on a 3-day school trip that she had been looking forward to. The preteen's all-too-adult response to the situation was to sue, claiming that the punishment was too harsh and did not fit the crime. Unbelievably, the girl, who had in the meantime gone to live with their mother, won the case. The Quebec Superior Court ruled in the child's favor and overturned the father's punishment, a largely symbolic ruling as the child was no longer living with him. Still, the father's lawyer expressed concern for what type of precedent the ruling might set, saying parents are going to be walking on eggshells from now on. "I think most children respect their parents and would never go so far as to take them to court, but it's clear that some would, and we have to ask ourselves how far this will go." Stephen and Catherine Miner were raised by their father in a $1.5 million home after their parents divorced in 1995. Although they were provided for very well, they took issue with the fact that their mother, Kimberly Garrity, wasn't the nicest mom in the world and didn't send them money on their birthdays. As soon as both kids were over the age of 18, they decided to take their mother to court for intentional infliction of emotional distress. Among the supposedly damning evidence was a birthday card with a thoughtful inscription that Stephen Miner deemed inappropriate because it didn't contain cash or a check. He also accused his mother of smacking him on the head once, saying he still suffers headaches from the incident, and of threatening to call the police if he didn't buckle his seatbelt when he was 7. Perhaps predictably, the court ruled that none of this behavior constituted extreme or outrageous conduct, and dismissed the case. Kimberly Garrity's lawyer speculated that the suit may have been an attempt at some type of revenge by Stephen Miner Sr., the children's father and Kimberly's ex-husband, which may not be so far-fetched. He is an attorney, and represented the children in their case against Kimberly. Long Island student Jordan Zeidman was promised $5,000 from his maternal grandmother at his 2007 bar mitzvah, the same gift she had given his siblings at their celebrations. Jordan had long had a strained relationship with his mother, Shirley Zeidman, who was not invited to the bar mitzvah but came anyway. Jordan's grandmother gave the $5,000 gift to Shirley to hold, and Jordan never saw it again. In 2014, Jordan, by then 19, decided to sue, and the case dragged on for a year and a half. Shirley Zeidman tried to claim in court that the money was never promised to Jordan, but an IOU for $5,000 in her own handwriting proved otherwise. In the end, a judge ruled that Shirley was liable for not only the original amount, but 9% interest over the 8 years the money had been withheld, as well as attorney's fees, a final judgment of about $11,000 in Jordan's favor. In 2014, New Jersey teenager Rachel Canning left her family home and went to live with the family of her best friend. Whether she was kicked out or left voluntarily remains in dispute, but shortly afterward she decided that if her parents didn't want to pay for her private high school and college tuition, she would try to force them to through legal means. The case made national headlines, as Rachel's parents claimed that she left voluntarily after refusing to follow simple rules, such as doing household chores and being respectful. The lawsuit was funded by Rachel's host family, who said they feared for her future without her parents' assistance. Rachel asked the court to declare her non-emancipated and dependent on her parents, and to order them to pay her tuition and living costs. However, her request was denied by the judge in March 2016, and shortly after the trial, Rachel moved back in with her parents. In September, Rachel announced via social media that she would be attending Western New England University on a scholarship. Amazingly, Rachel Canning's case was not the first of its type. In 2013, 20-year-old Richey also sued her parents, who are divorced, for college tuition. The case has a few similarities, in that Caitlin filed suit after going to live with a relative, with her parents claiming that she left after refusing to follow their rules or deal with the alleged drinking problem. Her mother, Mara McGarvey, whom Caitlin had been living with, says that Caitlin was told multiple times that if she were to move out, no more child support would be coming, and she would be on her own to find funds for college. In court, the judge ruled that Richey and Maura McGarvey were liable for $906 to cover Caitlin's community college expenses, but it didn't end there. After transferring to Temple University, Caitlin filed another suit against her parents, to the tune of $16,000, to pay for her tuition at the much more expensive university. This case was also settled in her favor, and the parents were ordered to come up with the money in October 2014. They have announced their intention to appeal, as soon as they can afford to. They've been trying to raise funds for an appeal through GoFundMe ever since the court's ruling. The man now known as Sean Russ had one of the most publicly troubled childhoods in modern history. For most of his childhood, he was Gregory Kingsley, a troubled boy with an alcoholic father and a frequently homeless mother, who was used to living in cars and never being in the same school for long. At the age of 8, he went to live with his mother and some relatives, but the arrangement only lasted a couple of years before Gregory was sent to foster care. He was living at a boys' ranch when he was found and taken in at the age of 10 by the Russ family, whose home gave Gregory the sense of belonging he had been missing all of his life. Then when Gregory was 12, his mother Rachel decided she wanted him back, and Gregory decided that legal action was the only way to keep his new family life. In a highly publicized 1992 custody trial that the media called a divorce, Gregory asked the court to terminate his mother's parental rights and allow his adoption to go forward. While Gregory's father didn't contest his adoption by the Russ family, Rachel fought a losing battle for her parental rights. The court ruled that Gregory had been neglected and abandoned, and that it would be in his best interest to grant his petition. Full custody was awarded to the Russ family, and Gregory spent the next 20 years trying to live a normal life in the aftermath of the landmark case, before finally speaking to the media about it in 2012. A 2014 lawsuit in the UK was filed on behalf of a 7-year-old girl against her young mother. The woman, who had been 17 when she was pregnant with the girl, allegedly drank heavily throughout her entire pregnancy, and as a result, the child was born with fetal alcohol syndrome. The child has severe brain damage and problems with development and memory, and her current caregivers filed the lawsuit partially to compensate for the additional medical care she will almost certainly need during her lifetime. The court heard evidence that the young mother drank up to 8 cans of beer and half a bottle of vodka every day while pregnant. Despite the court's admission that the mother's behavior was wildly irresponsible, it found that it could not be legally considered criminal, as it had not been proven that she had inflicted grievous bodily harm on a person by the legal definition of that term. The case was dismissed in December 2014. While countless lawsuits have been filed for wrongful death, only a handful have ever been filed for wrongful life. One of these is the case of Zepeda versus Zepeda, one of the first ever such claims, which was filed in 1963. The case involved a boy who was suing his father for damages due to the very fact of his existence. The boy alleged that his father had coerced his mother into sexual relations, resulting in the boy's birth, despite the fact that the father was married to another woman. Therefore, the boy was born out of wedlock. He sought damages due to the emotional distress and societal stigma of being an illegitimate child. The court threw out the case, finding that it could not be proven that the father had acted with malice or that the boy had been harmed by his illegitimate status. In its decision, the court pointed out that while they were sympathetic to the boy's argument, they had to consider the possibilities of the floodgates opening on lawsuits brought by anyone born under conditions that they didn't like. This case has often been cited as precedent in other wrongful life cases in the years since.